Hello, this is Sharon Adams here to talk about trademarks, and today we're going to talk about disclaimers. A disclaimer is a requirement that the USPTO will often require when a word in the trademark itself is descriptive of the goods or services in a trademark application. So let's look at what the USPTO says is a disclaimer. What is a disclaimer? It is a written statement that indicates that you, the applicant, don't have exclusive rights to a particular word or a design in your trademark. When a disclaimer is required, it does not physically remove any wording or design elements from your trademark. So, in other words, what it means is you have the rights to the word in the trademark, but only as part of the trademark. So, it's kind of an ambiguous concept, and I thought we would look at a few examples to see exactly how that works. So, here we go. I did a search for trademarks that have a disclaimer of the word coffee. That's a very typical word. So you can see Holly's Coffee here. They sell coffee. So the USPTO required a disclaimer of the word coffee because the word in the trademark is descriptive of the services or goods in this case, which is coffee. So they don't allow this person, Holly's Coffee, they don't allow this trademark to claim the word coffee except as part of Holly Coffee. And that's why all these different trademarks, Triumph Coffee, Baronet Coffee, they can all use the word coffee. They cannot go claim that another person is infringing because they're using the word coffee, because the word coffee is part of their trademark, but only as part of the entire trademark. So I thought I would look at another one, maybe not quite as common as the word coffee, which is the word elephant. And I was actually a little bit surprised to see, well, there's 15, as it shows 15 registrations that require a disclaimer of the word elephant. So here, for example, Elsa the elephant is the trademark, and the USPTO required a disclaimer of elephant, and they sell stuffed toys. So they're not selling elephants, and they don't specifically claim they're selling stuffed toy elephants. Nevertheless, because it's possibly that they could sell a stuffed toy that is an elephant, the USPTO required a disclaimer of the word elephant. I thought I'd look at this one, the Elephant Matrix, because they're for educational services. Well, what the heck? Why do they have to disclaim elephant? This is the trademark here, the Elephant Matrix. You can see that there is a disclaimer of the word elephant. It was required. Why? Well, when we look at the goods and services, we can see they're doing these educational services and developing, arranging, conducting educational conferences and programs, providing courses of instruction in the field of self-help and self-improvement through elephant conservation. So if they had just said they were providing self-help and self-improvement through conservation, they would not have had to disclaim the word elephant. But because they used the word elephant in their description of their services, the USPTO required a disclaimer. It's descriptive. That's when the USPTO requires a disclaimer. I thought another one that might be interesting to look at would be good. Good is widely used. There was so many trademarks that required a disclaimer of good. Why? Why does the USPTO require a disclaimer of good? We're going to look at this one here, which is just good in a stylized format for dietary and nutritional supplements. Here it is, good. Disclaimer of the word good for the dietary and nutritional supplements down here. Why did the USPTO require a disclaimer of good? Well, here's the office action. The proposed mark includes the word good. As the attached definitions demonstrate, the word good is a laudatory term used to describe excellence to applicants' goods. Because this word is a laudatory term, it is descriptive of the goods and must be disclaimed apart from the mark as shown. So that is what you are seeing here. The word good is disclaimed apart from the mark as shown. Well, what else is left in this mark? What is apart from the mark as shown? What's left is the logo. It's the stylized format of this word. And that is again shown here on this page. The only time you see the word good alone is when it's with a logo. Here it is down here with this one. It's good with a logo. Here it's good with a logo. just the word good with a logo. Here, over here, again, it's the word good with a logo in this square. What you will not see is the word good in a standard character format. In other words, the word good without a logo, because then in that case, the entire mark would need to be disclaimed, and the USPTO does not allow that. So, for example, you can see popping good. That has a standard character format here. There's no logo, but because of the word popping, the entire mark does not have to be disclaimed. And why am I saying that? Because that is another rule the U.S. Patent and Trademark Office has regarding disclaimers, which is in the Trademark Manual of Examining Procedure, an entire mark may not be disclaimed. So, what this means is that if your entire trademark is a word like good and it's in standard character format where there is no logo to go with it, the USPTO would require a disclaimer of the word good. That's all the mark is. It's good in standard character. Therefore, the entire mark has been disclaimed and the USPTO will not register it. So that is a very brief explanation of disclaimers, and I hope that was helpful.